Hello, viewers. In today's lesson, I shall be taking you through a legal examination of President Bill's COVID-19 state of public emergency. And at the end of this lesson, I hope that you'll be able to understand how the idea of state of public emergency developed and when it is appropriate to make such declaration. Secondly, I hope that you'll be able to understand the effect of state of public emergency and the time thresholds for state of public emergency to be effective. Lastly, I also hope that you'll be able to understand the legal implication of the said COVID-19 state of public emergency, that is the legal issue surrounding it. Now, the idea of state of public emergency has been developed through the influential theories of legal theorists. And one of these is A.V. Dicey. A.V. Dicey has contributed in this area through his words that there are times of tumult or invasion when, for the sake of legality itself, the laws must be broken. The ministry must break the law and trust for protection to an act of indemnity. A statute of this kind is the last and supreme exercise of parliamentary sovereignty. It legalizes illegality, combines the maintenance of law and the authorities of the Houses of Parliament with the free exercises of that kind of discretionary power or prerogative, which, under some shape or other, must at critical junctures be wielded by the executive government of every civilized country. Now, the underlying words carry some meaning which you have to understand. Now, act of indemnity means that it is law that legalizes illegality. In other words, it is an act or it is law that condemns an act had the state of public emergency not been declared. So, if rules and regulations are made to restrict the movement of people, that only happens, it becomes legal during the state of public emergency. But lifting the veil of public state of public emergency, it becomes illegal at normal times. That is act of indemnity. It legalizes illegality. Now, what does this mean? It legalizes, it makes those wrongful acts, had the state of public emergency not been declared, legal when it has been declared. So if X, Y, and Z have been illegal at normal times, declaring state of public emergency makes those X, Y, and Z actions legal. It legalizes illegality. Now, which under some shape or other must at critical junctures be wielded by the executive government. And this is only wielded. Who wields this power? It has been suggested that this is only wielded by the executive government of every civilized country. Now, this idea of state of public emergency has been recognized within the jurisdiction of Sierra Leone. And this is captured under Section 29, subsection 1 of the Sierra Leone Constitution 1991, Act number 6 of 1991. And this is said as follows: that whenever, in the opinion of the President, a state of public emergency is imminent or has commenced, the President may, at any time, by proclamation, which shall be published in the Gazette, declare that a state of public emergency exists either in any part or in the whole of Sierra Leone, or a situation exists which, if it is allowed to continue, may lead to a state of public emergency in any part or the whole of Sierra Leone. Now, the state of public emergency comes out of the opinion of the president, what he thinks, and not what others think. If he thinks that it is necessary, as per the constitutional provisions, to issue or to declare state of public emergency, he does it. So it is a matter of opinion and not a matter of rigorous legislation. Now, and this happens wherein the underlying words imminent and commenced are at play. and this will be discussed later. And this is done through proclamation. And proclamation means a decree, a declaration, a public statement which has the force of law, so long as it follows the constitutional requirement. Now, a gazette is a public document through which proposed legal legislations, laws, and even those that have been passed are being published. So it is through that document. Now, when to declare state of public emergency? State of public emergency is declared when two situations are at play. And this is captured under section 29, subsection 2 of the said constitution. Now, this happens in the first place when there are certain incidents that are yet to happen, but they are likely to happen. That is imminent. And these include imminent danger of invasion. So if the sun is about to fall from the sky, that is imminent. Though it hasn't fallen, but it is about to fall from the sky into Sierra Leone. It's imminent. We also have public danger, which clearly constitutes a threat to the existence of Sierra Leone. For example, if majority of Sierra Leoneans go on strike, that's public danger, which clearly constitutes a threat to the existence of Sierra Leone. Exactly. So, and also we have those incidents that have already commenced, which trigger the declaration of state of public emergency. And these include war, that is conflict. We also have actual outbreak of public order or safety, let's say disease, epidemic. For instance, the COVID-19 pandemic that has been declared as a world, as a global outbreak, pandemic by the World Health Organization. We also have occurrence of any disaster or calamity. So, if for instance there is heavy downpour of rain for like 3 good months, and Sierra Leone is at risk, geographically, state of public emergency can be declared. Now, the declaration of state of public emergency has effect, and these effects include the detention of persons, restriction of movements of persons, deportation and exclusion of persons other than citizens, and also other limitation of human rights. And this is captured under section 89, subsection 6, paragraph A to H of the said constitution. Now, the above corresponding consequences of the declaration of state of public emergency can empower other authorities to make others rules as well. In other words, when the president declares state of public emergency, other institutions within the government are triggered to issue different regulations, different orders, different rules to guide the conduct of that particular state of public emergency. So whatever comes from them is as a result of the declaration they made. It is influenced by the declaration of the president. Now, time thresholds. The time thresholds is important because it tells you at what point the state of public emergency becomes effective and at what point it ceases to become effective. Now, this is captured under section 29, subsection 10 of the Constitution. Now, in the first place, regulation ceases to have effect at the expiration of 90 days, approximately 3 months from the date upon which it comes into operation. So, in other words, if a state of public emergency is declared on the first day of January, it becomes less effective, or it ceases to become effective at the expiration of February and March. So January, February, and March constitute 3 months, a period of 3 months. However, Parliament can extend its operation. So this 3 months is subject to parliamentary extension. Now, Parliament can by two-thirds majority extend it to 12 months, subject to revocation before it ends. So, apart from the 3 months, Parliament can also extend the life of the state of public emergency to 12 months. So, in other words, it is only Parliament that has the authority to extend it to a period of 12 months. But the initial time frame for state of public emergency to be effective is 3 months and not 12 months. Another state, however, there is a catchy provision under Section 29, subsection 10. Now, or Section 29, subsection 14. Now, it says that another state of public emergency can be declared before and at the expiration of 90 days, notwithstanding its parliamentary limitations. So, in other words, before the 3 months expire, the president also has that power to extend the time to re-declare the state of public emergency. And if we critically look at this section, it also permits the president to also re-declare state of public emergency at the expiration of that 3 months. That is the last day of the operation of the state of public emergency, which means the president has the power to extend the state of public emergency, notwithstanding parliamentary extension. Now, to the state of public emergency declared by His Excellency President Julius Malala Bio, the COVID-19 state of public emergency. This was declared through his words that now, therefore, I, Julius Malala Bio, do hereby by this proclamation declare that a state of public emergency exists in the whole of the Republic of Sierra Leone with effect from today, the 24th day of March 2020, for a period of 12 months. This state of public emergency was declared to cover the whole of Sierra Leone and not to a district, to a village, to a town, or to a city. Secondly, this state of public emergency was declared to cover Sierra Leone for a period of 12 good months from the 24th day of March 2020. So, as we realized earlier, the Constitution requires that a state of public emergency declared by the president should last for a period of 90 days, that is approximately 3 months, and that it is only Parliament that has the authority to extend the life of that state of public emergency to a period of 12 months. Now, this state of public emergency has given rise to two effects. The first has been a 3-day nationwide lockdown, which legally limited the freedom of movement of persons from their homes to public places. So, or from their home to another home, so to speak. And secondly, this has given rise to a 14-day interdistrict lockdown. And this has been a legal limitation of the freedom of movement, human rights of persons living in Sierra Leone. Now, issues have been raised surrounding this COVID-19 state of public emergency. And this was captured through a report made by the Honorable Member of Parliament, Kandekola Yumkela, to the Sierra Leone Telegraph. That in the first place, he had issued that the state of public emergency had to be presented to Parliament for it to be ratified. And in the second place, that he doesn't agree with the loose interpretation of Section 29, subsection 10 of the said Constitution. Now, this issue of not agreeing with this Section 29, subsection 10 surrounds the provision that the president has the power to declare a state of public emergency for 90 days, that is approximately 3 months, and he further has the power to extend its life before the expiration of that 90 days or even at the expiration of that 90 days. So he has issues with that. Now, this issue that has been raised by this honorable member of parliament A similar issue was also raised under the 1978 Constitution. Now, this this issue was ruled on in the case of the State versus Usman and others, 1988. Now, this rule that was established is captured in the following: that where a section of an act dealing with general provisions conflicts with specific provisions, as in the instant case, that is state of public emergency, the specific provisions shall prevail over the general provisions, even though section 125 subsection 6, which requires placement of declaration before parliament, is a latter provision. It makes no difference where the latter provisions, that is section 19 subsection 4, are specific in their application. Now, what is a specific and general? What is a specific provision and a general provision? Now, a general provision gives the basic and fundamental initiation of a constitutional requirement, whereas a specific provision establishes the detailed requirement of a particular constitutional provision or constitutional act by a state authority. Now, under the 1991 Constitution, the general provision with regard to state of public emergency, more so wherein the state of public emergency has to be presented before Parliament for the purpose of this state of public emergency analysis, the general provision talks about those requirements wherein the state of public emergency has to be presented before Parliament, whereas the specific has to do with the president's side. Now, section 170 subsection 7 states that any others, rules, or regulations, captured regulations underline, it has to be laid before Parliament. Now, so the president, after declaring state of public emergency, these regulations have to be laid before Parliament. They have to be laid before Parliament. However, section 29 subsection 10 does not specifically require that when a state of public emergency has been declared and it's ongoing for the period of 90 days, that's approximately 3 months, it has to be laid before Parliament. It is not clear under section 29 subsection 10 of the Constitution of Sierra Leone. And this falls under the general provision. Now, the specific provision is that during a period of public emergency, the president may make regulations and take such measures as appear to him to be necessary or expedient for the purpose of maintaining and securing peace, order, and good government in Sierra Leone or any part thereof. So also under section 29, which is the specific provision on the president's side, this is a specific provision, and it states that the president can make such regulations. The catch here is that though a general provision exists that permits, that allows, that requires the state of public emergency regulations to be laid before Parliament, there is also a specific provision that allows the president, that permits the president to give detailed provision or detailed content of the regulations to the public. Now, if such issues are brought before any court in Sierra Leone, for instance, such issues will be looked into with due consideration of the rule established in the State versus Usman and others. And this rule is that where the general provision contradicts the specific provision takes preeminence. Now, another catch here might be that since the state of public emergency is accompanied by regulations that are made public, there might be no need for it to be laid before Parliament to be ratified and to be further made public again. And a further catch here would be that since the state of public emergency regulations are still running within a period of 90 days, that is approximately 3 months, then there is obviously no need for it to be presented before Parliament because the 90 days, approximately 3 months, has not expired. In other words, the president still has power to control the 90 days state of public emergency, approximately 3 months, before Parliament involves itself in the extension of the state of public emergency or the ratification of the regulations of the state of public emergency. Thank you for watching. Please like this lesson, like the video, and also subscribe for you to get subsequent notification of our lectures, our lessons online. And also don't forget to like our Facebook page. You can also follow us on Facebook